calling me a couple of days ago asking, should I borrow from my 401k, reinstate, and move on? My question to them was, can you afford to make the payment after that? The answer was no. I said, don't hit your 401k. And the lender can't ever levy on your 401k. It's protected in Florida. So then we talk about modification. And when we talk about modification, you want to be able to present the lender with a complete package of documents from your client. At least 30 days of pay stubs, 2 years tax returns, 3 months of bank statements, a financial statement, proof of insurance, and a hardship letter explaining how they got in that circumstance and why things have turned around. And provide that to the lender with the modification request. Most individuals, if they do a modification request, are just going to send it in and say, I want my mortgage modified. The lender comes back and says, oh yeah, we'll cut $12 a month off your payment. It really doesn't do them much good. As a foreclosure defense lawyer, what we do is we prepare a package and a specific plan. Here's what we want. We want principal reduced to this. We want it's a 7-year-old loan. We want to extend the term of the loan out another 7 years, roll all the arrearages back into the loan, reduce the interest rate to this, pay interest only for the first 5 years. Now they have a plan that they know what we want. So if they come back and say $12, we know they know we're not going to accept that. It becomes a negotiating process.
I have a quick question.
Mm-hmm.
I have heard, and has it been your experience, that if a homeowner is current on their mortgage, i.e. they don't have any late or missed payments thus far, that it is very difficult to achieve a modification?
Up until recently, it was probably impossible to achieve a modification and almost impossible to get a short sale if you're current on your loan. And people were scraping and continue to scrape to make their payment because they want to protect their credit and their credit scores. A lot of the lenders, up until the Obama plan got put into place, wouldn't talk to you unless you were 90 days past due. So you end up with this horrendous choice of depleting your cash reserves or messing your credit rating up. Under the Obama plan, at least on modifications, you're talking now. People can submit, even if they're current, and see if they can get something done. Now, once they're there, it's a little difficult to determine whether the lenders are actually giving those modification requests the same level of scrutiny as they are somebody who's behind, but they will accept them. Yes?
In Southeast Florida around here, how many people are qualifying under the Obama plan? I mean, how many do you see that actually qualify?
Within my office, my practice, I probably am somewhere around 60 to 65% right now. The ones that haven't qualified are really ones who have some significant financial issues but are insistent upon making the application. To send it in is really not all that difficult to do. It's accumulating the documentation, the cover letter, sending it off to the lender, and making a request while you're in the course of litigation. Some of the clients have husband and wife, neither of them have had jobs for 6 months, business failures, so they have no appreciable income. So it's become difficult for those folks. But people that have some sort of steady income, we're able to work it out so they will pass the net asset value test, which is one of the things that the government looks at, determining whether the value of the property can support a new loan amount or a payment at a certain level. Yes?
I have a question. You said at the beginning that you represent banks and you do both sides. You represent the consumer as well, the
Correct.
borrower. How does that work with conflicts of interest, and is it difficult? Is that an easy issue to resolve, or is it difficult?
Well, fortunately, the financial institutions I represent are small community-type banks that are located throughout the area. I don't represent any of the national lenders, so I don't usually have a conflict of interest problem arise because I don't have a loan going into default with one of my banking clients where it's somebody who's come to me or I represent, and if it is, I notify whichever client it might be, and I usually refuse the representation, which precludes a conflict between my bank client and my individual client.
Mm-hmm.
While you can certainly get a waiver of a conflict, I think that those are still not really well loved by the bar, especially in litigation matters, because no matter what you do, you still know things about the other party that it could be detrimental to them and beneficial to your other client. I think it's safer from a professional responsibility point of view to decline the representation and refer them out both to other counsel. So if you can get through the modification process, it works great. You get out of litigation, your client gets to keep the home, you move forward. And two other alternatives where the client doesn't keep the home is short sale or deed in lieu of foreclosure. A deed in lieu of foreclosure is a simple, quick way, if the bank will accept it, to get out of a foreclosure circumstance or possible foreclosure circumstance. What you're doing is you are deeding your property over to the bank, ostensibly in forgiveness of whatever debt is owed. You need to make sure, from a foreclosure defense attorney standpoint, that you're getting that release of the remaining debt. So if there's a $50,000 gap between fair value and what the mortgage is, you want to make sure the language reflects they're not going to pursue the client for that money. Deeds in lieu only happen generally if somebody runs a title search and determines there are no other interests on the property. If there's a second mortgage, if there's a lien, the bank's not going to take it because they don't want to be subject to that lien. They'd rather go through the foreclosure process. On the short sale, as I explained before, it's a sale of property for less than the mortgage amount. That is going to be something the banks are going to look at, and at the end of the day, tell your client, assure your client that they're going to walk away with $0 from the transaction because the bank's going to take everything after normal closing expenses. The other thing that clients feel a little bit comfortable or happy about is that your legal fee in a short sale is going to come out of the sale proceeds. So essentially, the bank is paying your legal fee, and that'll be on the closing statement. Whatever's left, the bank takes. The one thing that we always make sure our clients understand, and we advise them to talk to an accountant, is that on a short sale or deed in lieu, there are income tax ramifications. If there's $50,000 of debt that the bank is not going to collect from you, you are going to get 1099. That's going to be determined to be income. Debt forgiven, anything over $600 is a debt forgiven that has to be reported to the IRS.
Did the Obama plan not? I had heard that phantom income was going away essentially with the Obama plan.
Well, actually, it predates Obama. It's one of the last things that President Bush did was if it is your primary residence, if you meet certain residency tests under the IRS code, even though you get 1099 on it, you do not have to declare that as income. But if it's an investment property or you don't meet the test, then you are subject to being taxed on the debt forgiven. So my clients are made aware of that. We'll find a CPA to talk to about what the impact would be and whether they qualify under all the IRS code tests, because some of those are accounting mechanical things that, again, I had an accounting degree some years ago. It's not something that I feel qualified to advise my clients on. Of course, the option of last resort is bankruptcy. I don't do bankruptcy in my office. I do have a number of attorneys that I refer clients to. I don't tell them who to go to. I give them options, as you all should when you go into practice. Give your clients options on who to talk to, because you may want to refer them to your best friend who does bankruptcy, but they may go meet that friend of yours and they don't mesh. So I always give clients options, let them do the interviews and decide who they want to use. I think not only will they appreciate it, but if that person happens to mess the case up, you're not going to have a liability issue for referral to an incompetent lawyer. I'm not specifically familiar with exactly what courses are offered here at the law school that might deal specifically with foreclosure defense, but I can tell you things that you should consider taking are litigation-based courses. If there are consumer credit courses, even if there are courses that deal with real estate closings and how to handle a closing, what type of loss coming into effect on a residential purchase, those are all good courses to take. The National Consumer Law Center is a wealth of information. They're online. You can order books from them. I have found a number of interesting things in there that have aided my practice as I've gone through. Plus, they have a great online library of resources.